first case this morning is Ohio versus Dennis Swift. As you know, each side will have 15 minutes. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve 5 minutes, please let me know, and then when we get there, I'll give you the high five, and you'll know where you are. You can stop if you choose or finish out. You may begin.
Good morning. I would like to reserve 5 minutes for rebuttal. My name is Giovanna Scaletta-Bremke. I represent Mr. Dennis Swift. He was charged in the trial court 2 counts of burglary, 3 counts of aggravated robbery, 2 counts of kidnapping, felonious assault, all of those with 3 specifications, and also having weapons while under disability. The case proceeded to a jury trial here in Lorain County. He was convicted and sentenced to 12 years mandatory time. And essentially this case starts with some individuals in a home. They were there to record music. It was a social gathering in the home. One of the individuals stepped outside to retrieve some musical equipment. He was shoved back into the home by, what the testimony shows is 3 individuals outside. The individuals came in the home. They pistol whipped, beat, emptied the pockets of, and ransacked the home of the occupants inside. They eventually left the home and left in a car that was parked on the street. And my client, Mr. Swift, was identified by Facebook photos. 2 assignments of error. The first one is that the trial court denied Mr. Swift due process in violation of the 5th and 14th Amendment by retaliating against him for exercising his right to a trial as opposed to taking a plea.
And how was that retaliation demonstrated?
Well, I do cite to the Tucker case, which I'm sure you guys are aware of because it is a 2016 case out of this court. There was a colloquy before the plea negotiations were set on the record. The offer was 8 years. The judge had said, essentially when I read it, it looks like a promise to me that if you go to trial, it's going to be prison time and it's going to be more than these 8 years.
He also said it could be less, though, didn't he?
He did say it could be less, but he does reference it again before the sentencing that, there was the offer of 8 years. He chose not to take it, and then he gives him more than the 8 years. He gives him 12 years. So, again, citing the Tucker case, in which this court held that individual was punished for taking the case to trial,
And what were the facts in Tucker?
What was that?
What were the facts in Tucker?
In Tucker, there was a colloquy on the record in which the judge made similar comments, and he made comments again before sentencing, that there was some discussion before the trial, I believe in a final pretrial, where the judge said, if you take this to trial, I'm going to give you more time than what this plea is. And then again, he referenced it again in pretty stern words before the sentencing. And then the second assignment of error was that the appellant was not afforded effective assistance of counsel, in that the counsel had failed to object or bring to the attention of the court the fact that the preliminary hearing had gone past the 10 days. It's Criminal Rule 5B, which states that a preliminary hearing has to be held within 10 days if the individual is in jail. Mr. Swift was in jail, and the preliminary hearing was held on the 13th day. So Strickland v. Washington sets out the standard for the ineffective assistance, first being that the counsel's performance was deficient in in this case, certainly was deficient by not bringing that obvious defect to the court's attention. And this court in the Zaffino case had previously held that it's not an automatic dismissal of, if the preliminary hearing is not held within the 10 days, it's not going to be an automatic dismissal of the case. That's something that needs to be, I believe, is properly and timely objected to. It was proper. It needs some timely and proper action. And so counsel's performance in not bringing that to the attention was deficient. Because again, it's not an automatic, it's something that the council needs to do. And
How do you satisfy the prejudice portion of Strickland when counsel was, the appellant was indicted?
he was indicted, and I realized that even if the case, even if he would have objected, it could have been reindicted, it could have been refiled. But I do still feel like there's prejudice because we're dealing with things that could have happened or could have not happened. And, it could have been a discussion where maybe defendant felt like, well, they could dismiss this case and refile it anyways, I would have to post a new bond. But counsel should have brought that to the attention of the court because it is such an obvious, error in that rule is there, and it went past the 10 days, and Mr. Swift had brought it to the attention of counsel. Counsel didn't object. There was nothing on the record, and subsequently he was indicted. But this case, and this goes to the prejudice, this case would have been dismissed.
But wasn't he in jail already on a probation violation?
He could have been, but he was definitely in on this. He hadn't posted bond on this case.
But was he arrested also for probation violation? Was he detained for probation violation as well?
That I can't say with certainty that I would have to go and look. But I know that he hadn't posted on this case, so he was still being held on this case, that case number that related to this case prior to the indictment. So either way, he would have, even if that probation violation wasn't there, he would have been held on this case. So again, the second problem is the outcome would have been different. Obviously, it would have been different because it would have been a dismissal of the case. Had the counsel objected prior to the grand jury indictment, and once the indictment, case law says once the indictment is there, it's too late to object. So that was the time to object, and it had passed. I'd like to reserve the rest of my time.
Well, you've got 7 minutes, I can only give you 5 over.
That's fine.
That's
5
fine,
minutes.
just so you understand.
Sure.
Thank you.
Good morning, may it please the court, Elizabeth Lindberg on behalf of Appellee, the state of Ohio. Dennis Swift was convicted by a jury on February 2nd, 2016 of the following crimes: 2 counts of aggravated burglary, felonies of the first degree; 3 counts of aggravated robbery, felonies of the first degree; 2 counts of kidnapping, felonies of the first degree; felonious assault, a felony of the second degree; and having weapons while under disability, a felony of the third degree. He was also found guilty by the court of the repeat violent offender specifications attached to counts 1 through 8, and he was ultimately sentenced by the trial court to 12 years in prison on this case, 9 on the charges in the indictment, and 3 mandatory years for the attached firearm specifications. He now appeals and raises 2 assignments of error. The first assignment of error is the trial court denied appellant due process in violation of the 5th and 14th Amendments to the United States Constitution by retaliating against him for exercising his rights to not plead guilty and have his case tried by a jury.
And that was demonstrated by what facts?
The state maintains that there was no retaliation by the trial
No,
court.
but the other side, what is alleged to be?
What is alleged, that The basis of it is that Swift received a longer period of incarceration than he would have served if he entered into the offered plea agreement. The offered plea agreement at the conclusion of all, like, the state offered 14 years, that was rejected. The state offered 10 years, that was rejected. The final offer by the state was 8 years, that was also rejected. It was all placed on the record. And because ultimately he received 9 years plus the 3 mandatory for the firearm specifications, obviously 12 is more than the 8 he would have received if he had accepted the plea offer that was offered by the state in this case. However, it's the state's position that the court simply placed on the record the plea negotiations that were going on between the state and the defendant, and also the trial court was ensuring that Swift wanted to take his case to trial, both of which are proper actions by the trial court.
Then why mention it at sentencing?
What he actually did mention at sentencing was that the state was putting on its argument as to why it was requesting, I believe, a 19-year prison sentence. And the state explained to the trial court why it was requesting a greater sentence than what was originally offered, which was, and then I believe that it was 14 years, which was what was stated. The court said, in fairness, the plea discussions were placed on the record, and eventually the offer was 8 years. So I believe that was more responsive to the state, who was saying this is why we're asking for more than 14, and the court was responding, no, the final offer was 8. That's what you were actually negotiating in the end. And then the state responded, that's correct, Your Honor. The court said mandatory, the prosecutor said that's correct, and the court said which Mr. Swift declined, and then it went forward in the sentencing. The pertinent law is if a court makes statements from which it can be inferred that the sentence was increased due to a defendant's decision to proceed to trial, then that sentence must be vacated unless the record contains unequivocal evidence that the decision to proceed to trial was not considered when sentencing the defendant. There is a distinction between a trial court placing a plea offer on the record and a trial court pressuring a defendant to accept the plea offer. Those are both quotations from this court's case, State versus Turner. In the transcript at the beginning of trial, well, prior to trial commencing, the state did put on its plea offers, the 14 years, 10 years, 8 years, and the court was putting on the record all of this time and said what is the maximum that the defendant would be looking at, and ultimately if he was found guilty of everything, and the maximum sentence would be about 100, looking at 110 years. So it was then the court discussed with the defense attorney if he had gone through the calculations, if he discussed this with his client, he had, and then the court, the defendant said to the court, 8 years, 6 years, it's all too much. I haven't done anything to warrant this, so I'm willing to go all the way with it. And the trial court said that his job isn't to convince him to do one thing over the other thing. My job is to simply make sure that you understand the plea deal and potential consequences. And this is a quote from the court, and what I tell defendants is at this point I've read the police report and that's one version of what happened, and it doesn't look particularly good, but during the course of a trial, because ultimately I impose the sentence, sometimes I go into a trial and I have an idea based on what lawyers tell me of what the facts of the case are. I can look at the police report, but that's just words on paper, and sometimes I sit through the trial and I go, this is much worse than they led me to believe, and as a result of that, if convicted, I will impose more prison time than whatever the plea discussions were. On the other hand, sometimes it plays out just like the attorney said it would, and I may or may not impose more prison time. The other option is, it's not as bad. So ultimately, the court was saying, based upon what I hear, like Judge Schaefer suggested, the court also suggested if it's not as bad, maybe things would be different. And wouldn't be receiving more time, but it would be based on the facts and the evidence elicited at trial that the trial court would then have heard and consider in imposing a sentence. Also, after this discussion, the court heard a summary of facts, which was that Swift and 2 other people came to Mr. Hitchens' home. They held Hitchens and Lang, who were the 2 victims on the floor at gunpoint. Swift hit Hitchens in the head with a gun upon entering the home, and Hitchens was struck a total of 5 to 6 times with a gun during the incident. He also broke one of his fingers in trying to protect himself, and basically, as stated by defense counsel, ransacked the home and stole money from Mr. Hitchens, and stole phones and jewelry from Mr. Lang. And there's testimony from Jamie Knowles showing that this was a setup by Dennis Swift, and Jennifer Mounds testified that Swift had her follow him while driving on the day of the crimes and asked her to have an alibi for him later on. And then, after the conclusion of hearing all of that evidence, after trial was completed and he was found guilty by a jury, at sentencing, the court said, the court has considered the record, oral statement, sat through the trial, heard testimony of the victims, the witnesses. I've looked at the purposes and principles of sentencing under the revised code, and I've balanced the seriousness and recidivism factors present. Basically, Swift can't meet the first prong of what's required, which is to show that he made statements that can be inferred that he increased his sentence because he took his case to trial. That's just not present in this case. The second prong also can't be met because he evaluated what he saw during trial and considered the proper factors prior to imposing sentence. The second assignment of error that Mr. Swift raises is that he was not afforded effective counsel when the counsel failed to file a motion to dismiss and proceeded on the indictment after the failure to have a preliminary hearing within the prescribed time limitations. Of course, according to Strickland, two things have to be met. He has to be able to show that his counsel was deficient and that there was prejudice in that there would be a reasonable probability that but for his errors, the results of the trial would have been different. Basically, this court in Zaffino, the decision authored by Judge Whitmore, it states if an indictment is handed down before a timely and proper action is taken to secure a dismissal, the right to a preliminary hearing is extinguished. In this case, a preliminary hearing was held. It's not like Zaffino where there was no preliminary hearing held. There was one held in this case. It was outside of the allotted time frame. However, subsequent indictment was issued against Swift after that without a motion to dismiss being filed. Therefore, once the valid indictment was filed, there's no right to a preliminary hearing at that point. That right is extinguished. Zaffino, in that case, the court said an otherwise valid indictment need not be dismissed merely because it was returned after the time limits imposed on a preliminary hearing. Again, I believe Zaffino is misread by Swift in that failure to provide a timely preliminary hearing is dismissal, but it's akin to a nolle prosequi, where another prosecution for the same offense is permitted. So as discussed previously with defense counsel, assuming there had been a timely motion to dismiss, the case could have been brought directly to the grand jury and an indictment still would have been issued, as it was in this case. This court previously in State v. Leach and State v. Ross has addressed ineffective assistance of counsel arguments involving failure to file a timely motion to dismiss based upon preliminary hearing issues and found them to be lacking. As far as the Strickland standard states, counsel was not deficient in this case because there would have been an indictment anyway. And also, Swift cannot show that he was prejudiced by this because, again, there would have been an indictment, but beyond that, that does not mean the result of the trial would have been any different. The trajectory of the case might have been different, and it might have been dismissed at the municipal level and then gone on to the grand jury, but that has no bearing on the evidence and the testimony that was presented at the trial. If there aren't any questions.
Let's just assume for a moment that there was no indictment in this case.
Yes.
Would you still maintain that counsel was not deficient?
If there had been no
indictment.
counsel was deficient if there had been no indictment. I don't know that that would be the same argument.
I totally understand that. I think the state is arguing that, first of all, the first prong of Strickland is not met because he wasn't deficient, and second of all, it's not met because there was no prejudice.
Correct.
But if there had been no subsequent indictment and the preliminary happened out of time,
Sure.
which it did, and the case proceeded, is it the state's position that counsel was not deficient?
I think I don't know how to correctly answer that question. I suppose it would be an entirely different incident. If an indictment would have been issued, I guess, is all I can answer. I don't know if, even if there hadn't been what I'm saying as far as Zaffino is concerned, even if there hadn't been a preliminary hearing at all, it would have gone and an indictment would have been issued.
Well, I'm asking you to just suspend that thought. I mean, only because that is what happened in this case.
Yes.
Okay. But I think appellant's position is there was a small window of opportunity to take action, which would have meant the dismissal. And whatever the effects of that, let's also not think about. But there would have been a dismissal, and council did not take action. There was not a dismissal. You're saying, well, an indictment happened, so it doesn't matter, and I understand what you're saying to me. I just want to know if the state's position is that even outside the fact that there was an indictment in this case, which may or may not obliterate the second prong of Strickland, is it a deficiency of counsel to fail to make that motion to dismiss after the expiration of time for a preliminary hearing?
I don't know the case law on that. I cannot say that I would be arguing that that counsel wouldn't have been deficient for that, because maybe then it would have changed the outcome in this hypothetical. It might have changed the outcome of what was going on with the case. That's obviously, I'm suspending.
And I understand the difficulty, because Strickland requires that you prove both, so you're looking at me going, what difference does it make? And I'm only saying that, I'm only asking the question because I'm trying to understand the state's position, you know.
Sure, I suppose I'd have to look more at what the case law is on deficiency of counsel and whether or not that would be warranted in that case. Unfortunately, I never heard that.
Okay.
You still have 2 minutes if you wish to use it.
I think I'm okay. For the foregoing reasons, the state of Ohio requests that this honorable court overrule Swift's assignments of error and affirm his convictions and sentence.
Thank you.
Thank you.
You have your 3 minutes.
Okay, good. The state makes the argument that on the first assignment of error, that plea negotiations were just simply placed on the record. However, the trial court had brought them up again at the sentencing, and he says, I have a quote here, Mr. Swift, he declined the plea. So again, right prior to sentencing, that's in the frame of mind, that he did decline the plea negotiations, and he warns that the time could be much worse, is the direct quote, and it was not just ironic that it was four more years. And the trial court also, prior to the trial, says you're entering into uncharted territory. So again, these foreshadowing of what eventually is 4 more years of prison than what the plea negotiations were. For the second assignment error, again, the state can't answer the question about having no indictment, because we're all looking at this in hindsight. But the fact remains, there was a deficiency, there wasn't an objection, there wasn't a motion to dismiss, and it did go 3 days over the 10-day time period as prescribed by Criminal Rule 5B. So we're all looking at this saying, well, there was an indictment subsequently, there wasn't a dismissal. In this case, we proceeded to trial. But without all of that, there could have been a dismissal completely of the case, and that didn't happen. So again, we'd ask that you remand the case to the trial court, and that's all. Thank you.
Thank you. We will take the case under advisement, send you a copy of our opinion when it is issued. You can always find it